And now I'm deeply honored and privileged to have the pleasure of introducing the president of the National ACLU Board, Professor Nadine Strossen from the New York University Law School. Professor Strossen has written and lectured and practiced extensively in the areas of constitutional law, civil liberties, and international human rights. And in 1991, she was elected president of the ACLU. Since then, she has accumulated uncounted frequent flyer miles, several of them on trips to Montana, and among her other degrees from Harvard University as an undergraduate at Harvard College, or Radcliffe, I assume, and the Harvard University Law School, where she was an editor of the Law Review. She also has an honorary doctorate from Rocky Mountain College, University of Montana. Let that be a little bug in your ear, and from the University of Rhode Island. She's been widely recognized for her work, which includes numerous scholarly publications, 150 or more at this point, because the note I have is from 1997, so I suspect it's more than 150 now. Her book, Defending Pornography, Free Speech, Sex, and the Fight for Women's Rights, was published by Scribner in 1995, and another book co-authored with other colleagues titled Speaking of Race, Speaking of Sex, Hate Speech, Civil Rights, and Civil Liberties, was published by the NYU Press in 1995. These publications are available at Fact and Fiction and hopefully at other bookstores around Missoula, and I recommend her provocative work for you for its intellectual challenges and the grace of its prose. Now I'm pleased to turn the microphone over to Professor Strossen and to welcome her to Montana and all of you to Missoula. Thanks for being here.
Thanks a lot. Thank you so much. Well, it's really great to be here. I'm delighted to talk to all of you. I know that you have been staunch supporters of free speech here in Montana, where there have been relentless attacks against free speech, and in particular against the usual suspect when it comes to censorship, namely pornography or sexually oriented expression. And the reason why that is always the usual suspect when it comes to censorship has to do with America's puritanical heritage. Here I'd like to quote my fellow Minnesotan, Garrison Keillor, when he was testifying in Congress in 1990 in defense of the embattled National Endowment for the Arts. Garrison Keillor, and of course it was embattled, why? Because of sexually oriented art that was funded. Keillor said, "My ancestors were Puritans from England who arrived here in 1648 in the hope of finding greater restrictions than were permissible under English law at the time." I have to tell you, I so highly value your efforts and your support, because I know how hard this struggle can be. I know it from personal experience. So I want to give you a pep talk from my perspective as head of our organization, which takes on more free speech cases and causes than any other all over the country, including countless instances in which we come to the defense of sexually oriented expression. And most recently, by the way, you can guess the target. It has been the Star Report, which is being censored by various public schools over the internet. And so we have had to come to the defense of that latest example of embattled sexually oriented expression. I want to thank all of you and congratulate you for your vital and courageous contribution to First Amendment freedoms. You know, it's one thing for me to come in, give a speech, and then leave in a few hours and go back to the somewhat less hostile, somewhat less censorious atmosphere of Manhattan, New York, where I live. You know, it used to be a free speech zone. If I can just segue for a second. You know that the United States Supreme Court has held that whether something is obscene and therefore completely beyond protection of the First Amendment free speech clause when it comes to sexually oriented expression. The court has said that depends on local community standards. And way back in 1982, a federal judge in New York held that nothing could be obscene in New York because our community standards were so low, or depending on your I like to think that our community standards were too high, but toward free speech. But that was before Rudy Giuliani was elected mayor of New York. I don't know if you've been following his crackdown on sexually oriented expression. And unfortunately, so far, we have been losing a battle against his so far successful effort to completely exile all adult-oriented businesses from the city, including lesbian and gay bookstores. And one of the other targets is sexually explicit dancing, strip clubs. And I have in front of me a cartoon from the New Yorker magazine, which is one of my favorite sources of cartoons, along with the newsletter of the Montana Civil Liberties Union, which also is a great source of cartoons. But the New Yorker shows these gentlemen at a what used to be a strip club, and standing on the tables, on all of the tables around them, are women that look like Barbara Bush and dress like Barbara Bush. And one of them says to the other, okay, maybe it's not as exciting as the old clubs, but I doubt that Giuliani will try to close it down. Well, but of course, New York is not the hostile atmosphere that is faced in other parts of the country, including here in Montana. So I really have true admiration and respect for people like you who stay in the more hostile communities and continue to face opposition from anti-pornography activists and some politicians. And I'm so happy we have elected officials who are strongly defending free speech and other civil liberties who are with us today. I think they too show real courage and deserve to be honored. You know, the reason why it's so important for you to keep up the battle here is that no matter how many victories we might win in the United States Supreme Court, free speech is not going to exist as a tangible, practical reality unless we have people in every community who are willing to actually implement it, to make controversial publications and materials available. So my heroes and heroines always include, all over the country, the bookstore owners, the librarians, the teachers, the movie theater owners who actually exercise First Amendment rights and therefore make it possible for other people to enjoy them. And you're, again, you are my heroes and heroines, and I'm honored to be here with you. Scott asked me to focus on the newest censorship battles that we're facing in our newest communications medium, namely cyberspace. And on the one hand, this is a very hot, current topic. On the other hand, though, it raises age-old questions, and I think it's very important to look at this seemingly new controversy in a historical context. Throughout history, every single time a new communications medium has made it easier, faster, cheaper to convey ideas and information, it offers to enhance individual freedom and effective participation in democratic self-government. So human rights activists are always very excited about these developments. On the other hand, those of a more authoritarian bent have a very different reaction because they see these expanded communications opportunities as very frightening and potentially dangerous. So throughout history, each new medium has promptly been followed by calls for censorship. In the German city of Mainz, where Western printing was invented in the 15th century, a censorship decree was immediately thereafter issued. When movies were invented, they showed vaudeville dancers and even bare ankles. Traditionalists were absolutely outraged, and they immediately sought a ban. And I assume you know it wasn't until the second half of this century that the United States Supreme Court finally held that movies do come within the First Amendment. For the first half of this century, the Supreme Court said First Amendment doesn't apply to this frightening, dangerous new communications medium. When the radio arrived on the scene, a typical study worried, quote, Parents have become aware of a puzzling change in the behavior of their children. The telephone was no exception to this universal fear of all new media. Soon after its introduction, a noted psychiatrist accused the phone of driving people permanently insane. And of course, television. Television has been blamed for a range of social problems, including violence, throughout its entire existence. So the current bipartisan attacks on TV violence, which culminated in the V-chip requirement, are part of a very long tradition. In fact, the first congressional hearings on TV violence were held back in 1952, when fewer than 1/4 of American households even had TV sets, when the violence rates were among the lowest in the century, and when youth violence was actually decreasing. But so eager were politicians and the public to blame TV for something that they attacked it for problems that they didn't even yet have. Today's fears that we're hearing about the internet are the usual suspects that we've seen throughout the ages, and you know what they are. Impressionable young people, sex, violence, crime, idleness, alienation, anti-authority, extremist potential, isolation, commercialization, bad grammar, bad manners, bad attitude. Now, that's not to belittle these concerns, but rather to observe that it is always the new media kid on the block that is blamed for our social problems, and cyberspace is no exception. In this country, of course, the single most controversial, embattled type of expression in cyberspace, as in all other media, is sexually oriented expression. I want to go back to that wonderful Garrison Keillor testimony in defense of the NEA. And one of the other barbs that it included was against the double-edged nature of Americans' traditional love-hate relationship toward sex and sexual expression. And we're certainly seeing that inconsistent attitude every day in the recent past. These inconsistent attitudes are at best ambivalent and at worst hypocritical. In Keillor's words, if Congress doesn't do something about obscene art, we'll have to build galleries twice as big to hold the people who want to see it. And if Congress does do something about obscene art, the galleries will need to be even bigger. So, consistent with that love-hate attitude towards sexual expression, when the internet first hit the public and political radar screen, it was thanks to publicity about sexual materials online, including exaggerated, distorted, hysterical publicity. And that publicity immediately launched censorship crusades, which are still ongoing at all levels of government, all over the country, with overwhelming support from politicians of both major parties. From a free speech perspective, that's the bad news about online sexually oriented expression. There is a lot of good news, though. Just as most elected officials have supported censorship of online sexual material, the courts have provided a welcome and dramatic contrast. So far, the ACLU has brought constitutional challenges to 5 laws that censor sexually oriented expression online. 1 congressional statute, the Communications Decency Act, or CDA, and 3 state laws, those in New York, Virginia, and New Mexico, and also 1 local law in Loudoun County, West Virginia. And by the way, all of you who are ACLU members and supporters should be very proud. This is 100% of all cases that have been brought against laws censoring the internet have been brought by our organization, and we have won every single one of them. And the decisions in our favor, or I should say in favor of free speech, have been joined in by judges completely across the ideological spectrum who have been appointed by every president from Richard Nixon on. So I think this is a very important point to make. When we advocate the First Amendment should apply fully and robustly in cyberspace, including to sexually oriented expression, that is not just some crazy, radical, ACLU notion, that is a notion that has been subscribed to by every federal judge before whom that argument has been presented, including the entire United States Supreme Court. But that doesn't mean that the battle is over. You know, we keep winning these cases, but there is so much political capital to be gained by being tough on porn, tough on crime, and some connection is often mistakenly made between those, that politicians keep going back to the drawing boards, and we are still fighting these battles. And by the way, one of the arguments that we try to make, and some of the cases we have resolved through negotiation and settlement, is we point out what a waste of taxpayers' money this is to keep passing these clearly unconstitutional laws, because not only do the taxpayers have to pay for the defense that the governmental unit has to put up, but often they end up, to add insult to injury from their perspective, reimbursing the ACLU for our lawyers' fees as well. So you might try that pocketbook argument to people who might not share your passion for free speech. For any detailed information about any of these lawsuits, I commend to you the ACLU's excellent award-winning website. I hope most of you have seen it. It's on the web at aclu.org, or keyword ACLU on AOL, and it includes pleadings and briefs as well as opinions and other materials about all of these cases. I believe that the free speech issues are essentially identical regardless of what the medium is, and that's exactly what the ACLU argued in our historic challenge to the CDA, and of course the Supreme Court's landmark decision last year, which I'm so thrilled is going down in history under the name of Reno versus ACLU. The Supreme Court endorsed our approach. So I thought what I would do is to first briefly outline the general arguments against censoring sexually oriented expression, and then explain why those arguments apply fully in the cyberspace context, indeed even more strongly in the cyberspace context. And finally, time permitting, I'll touch on some of the many ongoing battles we're still fighting for online free speech. So with that roadmap in mind, let's start with some of the basic principles that govern protection of sexually oriented expression. As I keep saying, this has always been a major target of censorship in this country. So a few years ago, when Scribner approached me and asked me to write a book on the subject, I jumped at the opportunity. It was my very first trade press book, and I learned that authors do not have free speech rights, at least first-time authors, when it comes to matters such as cover and title. I'm sorry I don't have the cover of the hardback here with me. It's extremely provocative. Let me put it this way. It's neon colors, you know, flaming orange and purple and pink, and the big word, they split the word pornography so that somebody has it. I wasn't exaggerating, was I? I was having only published in law reviews, which mostly looked like that. I was a little bit shocked, and I have to say, when I first saw it, I was horrified. I didn't have any bargaining power, and I called one of my friends who is a professional writer for the New York Times, and I described it to her over the phone, and she said, well, Nadine, the main thing you have to understand, and the main thing you want your book to do is, if it's on a bookshelf in a bookstore, is it going to jump out at the person walking past? And I said, Claudia, this book is going to commit sexual harassment against the person walking past. And let me just, one other quip, because the title itself was also very in your face, and not quite accurate in some ways, some connotations, defending pornography, free speech, sex, and the fight for women's rights. When I showed this to one of my friends and an ACLU colleague, Margie Hines of our Art Censorship Project, Margie, who had written a book on a similar topic with a much more academic title, you know, the kind that has a colon halfway through, she said to me, dripping with sarcasm, and I think a little bit of envy, she said, gee, Nadine, couldn't they work the word orgasm into the title, too? Well, what initially made me squirm was this word, as I was starting to say, the way it's subdivided and see pornography. And that gets to a very important substantive point. You notice I keep using the word sexually oriented expression. The term pornography has no legal significance. And now I'm going to put on my law professor hat for a minute, if you'll permit me, because the terminology here is something we should be very careful about. The public, the media, politicians, even a lot of lawyers tend to use several words interchangeably that actually have very different legal significance. For example, obscenity, pornography, indecency, offensive speech, smut, all refer to sexually oriented expression. But the Supreme Court has always rejected the notion that just because expression, and by the way, when I say expression, I mean words or images. The Supreme Court has always said the mere fact that words or images, expression, are about sex is no reason to deny constitutional protection. To the contrary, the very first time the court confronted this issue in 1957 in a case called Roth versus United States, it made a statement that I think surely has to be one of the least controversial pronouncements that has ever issued from the United States Supreme Court. It said the following: sex, a great and mysterious motive force in human life, has indisputably been a subject of absorbing interest to mankind through the ages. I would add womankind as well. It is one of the vital problems, well, I'm not sure I like that word problems of human interest and public concern. As I say, that was a very uncontroversial pronouncement, but having said that, the court immediately went on to create and carve out of the First Amendment's plain prohibition on censorship an exception for one relatively narrow category of sexually oriented expression, which it labels obscenity. Obscenity is the relatively narrow slice of expression about sex that is exiled from the First Amendment pale, beyond the First Amendment pale. At least in theory, it's relatively limited because to be found obscene, the material has to satisfy 3 criteria, one of which is that it lacks serious literary, artistic, political, or scientific value. And easy acronym, just think of SLAPS. Okay, if it's got any value in those categories, and the value is determined by national standards. It's not dragged down to the lowest common denominator of the least tolerant community. So we've been rather successful as a practical matter in defeating obscenity prosecutions. Having said that, we have always opposed the obscenity exception as completely inconsistent with First Amendment principles. And by the way, the last time the Supreme Court revisited the issue, it was split 5-4. So we have a lot of allies on the court on this issue as well. And if anyone is interested, I would be delighted during the question and answer session to explain why we even oppose the obscenity exception. But for present purposes, that issue is beside the point, because the battle that we're fighting in cyberspace is just to hold the line at obscenity, since Congress and state legislatures and other government bodies are trying to outlaw more sexually oriented expression online than just the obscenity that would be criminalized in the traditional media. In other words, they want to take expression that can be completely lawful in books and printed publications and make it a crime to put that same material online. So the CDA, for example, to the extent that it simply carried forward the traditionally prohibited categories of obscenity and child pornography, that is material that involves the actual use of a minor in its production, to the extent that just simply applied to cyberspace, established exceptions to the First Amendment and other media, we did not challenge the CDA for practical reasons. We've lost those battles. But what we did challenge was the extent to which the CDA went beyond traditional illegal categories of obscenity and child pornography, and also purported to criminalize indecent and patently offensive expression. By definition, material that does have serious literary, artistic, political, or scientific value, and yet Congress, by huge sweeping majority, still wanted to make it criminal online. Now, the term pornography is equally problematic. It has no legal significance. According to the dictionary, it means only sexually oriented expression that is intended to be arousing, sexually arousing. But that is not how we actually use the term. We use it in a pejorative way for whatever sexually oriented expression we don't like. As I quote, one wit in my book says, what turns me on is erotica, what turns you on is pornography. And the demonization of that term has real adverse political and practical consequences. For example, once the Communications Decency Act was billed as regulating cyber porn, it became politically very difficult to vote against it. After all, no politician wants to be accused of being soft on porn. And we were actually told that by many of the folks in Congress during the lobbying process. I can't tell you how many of them said to us, I know it's unconstitutional, but I dare not vote against it. So that's why the sop that they threw to the First Amendment was an expedited judicial review process, which is how we went straight from a special 3-judge federal court to the United States Supreme Court in record time. But precisely because the term pornography has no precise legal meaning now, about 2 decades ago, some feminists seized upon the term as a label for a supposedly new subset of a supposedly different category of sexually oriented expression that they wanted to outlaw under new laws because they argued that it caused a different kind of harm from the harm that was addressed by the traditional anti-obscenity laws. And the most prominent feminists that led this movement were Catherine McKinnon, who is a law professor at the University of Michigan, and Andrea Dworkin, who is a writer in New York. They took the term pornography and they wrote model laws that were passed in a couple of jurisdictions. And the essential definition is sexually explicit expression that is subordinating or degrading or demeaning to women. They believe that this expression promotes discrimination or violence against women. In contrast, the harm at which traditional anti-obscenity laws are targeted is a different one of underlining conventional morality or traditional family values. McKinnon and Dworkin and their supporters were very successful for a long time, and until recently, they were so successful that many people in the public and the media and government believed that if you are a feminist, you must support censoring pornography. What was less well known was that there were a whole group of women's organizations and prominent women leaders who opposed censoring pornography, no matter how you define it, including what I call the McDworkin definition, not because of elevating free speech values above women's rights values or concerns about women's safety and well-being, but for exactly the opposite reason, because of the conviction based on experience that censoring pornography would do more harm than good, specifically to the causes of women's dignity, women's autonomy, women's safety, and women's equality. I wrote my book to set out that feminist anti-censorship perspective. But I want to make clear that I was speaking not only for myself, but for many prominent women that I really admire and I've had the pleasure of working with in the feminist anti-censorship movement. Women such as Betty Friedan, who I think of as the founding mother of modern feminism, the founding president of NOW, Faye Waddleton, the longtime president of Planned Parenthood, and many feminist writers and activists. Now, when I was describing the law and the concept that's advocated by the McDworkinite feminists, you may recall I kept talking about a supposedly new definition of a supposedly new category of sexually oriented expression that caused a supposedly different type of harm. And the reason I throw in that word is I am pointing to the inherently, inescapably vague and subjective nature of any of these so-called definitions. No matter how we label it, no matter how we define it, inevitably, any law that targets any sexually oriented expression on the theory that it causes some nasty or evil or dangerous thoughts, any such law is inevitably going to endanger all sexually oriented expression. In that vein, I think the only candid definition we ever got of the category of sexually oriented expression that should be illegal is the one that's probably most familiar to the highest percentage of this audience. It was the famous statement by Justice Potter Stewart on the Supreme Court when he said, "I cannot define it, but I know it when I see it." Now, the problem is, of course, that everybody sees a different it. And the same is true when we use the supposedly pro-feminist definition. No two feminist women can possibly agree as to whether a particular image is liberating and empowering and exciting on the one hand, or subordinating and degrading on the other hand. And I have, to titillate you, I have examples in here. There are pictures that illustrate that. But before you get too excited, these are not the kind of pictures that would ordinarily expect to be found in a book with that kind of title. Let me just describe one of my favorites is a picture of former Attorney General Ed Meese. Fully clothed, don't get too excited. You may remember that, but this would fully satisfy this definition. And what I did was put in here pictures that I thought would appeal to everybody in the sense of no matter what your political values or religious beliefs or other aspects of your ideology, you would find something in here that you would say, why is that being censored? How can that possibly be attacked? I mean, I have religious imagery in here for those who might be supportive of traditional religious values, which would clearly satisfy the definition of illegal pornography. So why is Ed Meese in here? This is just kind of a fun aside. I debate Ed regularly on censorship. We're still on the stumping tour all over the country. When he was Attorney General, of course, the infamous Meese Pornography Commission issued a report that wanted to outlaw even a wider category of sexually oriented expression than is now outlawed. And there was this kind of irony that when he had the press conference to announce the commission's report, his bank of microphones and his podium was set up, I'm looking at the picture right now, in a hall in the Justice Department beneath a huge statue of a naked woman who represented justice. You know, the photographers were just snapping this image up with glee. You know, from some images it looked like his head was in her crotch. And the particular image that I chose for the book was from Esquire magazine because I really liked the caption. You have her pendulous breasts hanging right over Ed's head as he's denouncing pornography. And the caption is, "Tits and ass." Let me just give you, I want to give you one example of how even no two feminist women can possibly agree, as I was saying, and one of the images in here illustrates that. It was the cover of a lesbian pornographic magazine called On Our Backs, and on the cover it's got a model, Asian American model named Dawn Wan, who was wearing a flame-colored leotard with flame-colored body paints, and there are images of flames flickering around her feet, and it's called Dawn Wan in Flames. She had chosen this image herself, and the editors loved it because they said it was hot and a sexual turn-on. And they also thought it was, she's very strong position, her hands on her hips and her head thrust back. And this is published in San Francisco, where there's a large Asian American population. And the editors in Dawn Wan thought this counters negative stereotypes about passive Oriental ladies. So they thought it was strong and empowering. But there was another group called Dykes Against Porn that attacked this cover all over the country as, to quote the head of the Seattle chapter of Dykes Against Porn, they said this just shows that white dykes want to set fire to Asian dykes. You know, a rather literal interpretation, and I I certainly defend their right to look at it that way, but the point is they should not arrogate to themselves the right to, the power to take away the right to look at it and enjoy it and appreciate it and find some different meaning in it. So the inevitable subjectivity in deciding which sexual expression is offensive means that not only all sexual expression is going to be in danger, because there's no realm where our perceptions are more subjective and more individualized, but the problem is even worse, because what is always particularly endangered is any expression on behalf of individuals or groups who are relatively powerless, unpopular, or marginalized. And unfortunately, that includes women and advocates of women's rights, including reproductive freedom, and also lesbians and gay men and advocates of their rights. In my book, I give many examples, and now I'm just going to confine myself to one because it ties into the internet theme. You know, our clients in Reno versus ACLU were not what the stereotypes that might jump into your mind when you think about that awful provocative term, pornography. Our clients include, and before I give you some examples, let me say, the government admitted and the courts held that all of their expression would be criminalized as patently offensive and indecent under the Communications Decency Act. Our clients included Planned Parenthood Federation of America because of the sexually oriented information about abortion and birth control. It included Human Rights Watch, which was the first international human rights organization to have a women's rights project because of the reports that they disseminate about human rights violations around the world, often, unfortunately, tragically, include sexual violence against women. Our clients included many, many lesbian and gay-themed and AIDS information sites. I find it absolutely tragic that women who see themselves as feminists, such as McKinnon and Dworkin, joined with the Christian Coalition in advocating for this law that would have criminalized that kind of important expression on behalf of women's freedom and freedom for lesbian women, among others. And the examples that I give in my book that fit into this pattern of disproportionate punishment of expression on behalf of disempowered groups such as women, so that I say women have the most to lose by this kind of censorial regime, women among other disempowered groups. It's not just a coincidence. It actually follows from the very rationale of the McDworkinite feminists themselves. And I have to say, I agree with their premises. I just radically disagree 180 degrees with their supposed solution. Their premises as to what the problems are that we live in a patriarchal society in which gender discrimination is still rampant, both as a matter of law and as a matter of culture. I couldn't agree with them more. That is why the ACLU still is spending such a huge amount of resources on behalf of women's rights. And I know you've got very important women's rights cases right here in Montana, and that's true in the rest of the country. Studies have been done all over the country of judicial systems, what are called gender-biased task forces that study how women are treated adversely in our courts, whether women are lawyers, whether women are witnesses, whether women are plaintiffs, even when women are judges, and that has an impact on the justice or the injustice that's meted out. So I couldn't agree with the pro-censorship feminists more in their diagnosis of the problem, gender discrimination in our legal system. Therefore, I absolutely reject their supposed solution, which is you give to this discriminatory, patriarchal, gender-biased system this open-ended, subjective weapon that can be used in such a discretionary and subjective way. Of course, it is completely predictable that the tool is not going to be used in a way that is friendly to women's rights. But I hasten to add, though, I certainly wouldn't want Andrea Dworkin or Janet Reno or any feminist or woman to enforce this law either. The inherent subjectivity is what is the problem to anybody who is an advocate of individual freedom. So now I've just laid out some of my reasoning in the book for the conclusion that censorship of sexually oriented expression no matter what you call it, it deeply violates women's rights. I think you're all familiar with the First Amendment rationale for opposing that form of censorship. I think I'll just very quickly summarize. I know there are many lawyers in the audience, but I don't want to leave out the non-lawyers. What is at stake here, as the Seventh Circuit found when it ruled on one of the McDworkinite laws that was actually enacted in Indianapolis in 1984, in a wonderful opinion that was summarily affirmed by the United States Supreme Court. That is to say, the court thought the First Amendment principles were so straightforward that the court didn't even receive briefs or hear oral arguments, which is a very unusual procedure. But what was at stake was the most fundamental principle of our free speech jurisprudence. As Justice Brennan said in one of the flag-burning decisions, the bedrock principle of our free speech jurisprudence, that government may never censor speech merely because the majority, even a large majority, in a particular community disagrees with or is offended by the idea or viewpoint that the speech conveys. And when you think about the whole McDworkin approach to sexually oriented expression that should be illegal, it is precisely viewpoint discrimination. The prohibited viewpoint is a viewpoint that is supposedly subordinating or degrading toward women. And of course, I profoundly disagree with that viewpoint myself, but as with every other viewpoint with which I disagree, you know the old Voltaire quote, I will defend to the death your right to express it. So, and I think that ultimately is the principle that should be used to strike down all anti-obscenity laws as well. Well, that's the quick and dirty overview of the ideas discussed in my book, so to speak, the reasons why sexually oriented expression in general should not be subject to censorship. Now let me turn specifically to the cyberspace context. All of those ideas carry forward, and the Supreme Court agreed with us last year that there is no justification to relegate cyber speech to a second-class status under the First Amendment, contrary to what the court had done and continues to do with respect to the broadcast media. The court's two most important rationales, and so one of the major debates we had going into the Supreme Court, and you could hear I went to the Supreme Court argument, the justices were trying to wrestle with, among other important questions, is cyberspace more like traditional print or telephone, which have received the highest degree of First Amendment protection, or more like radio and TV, which has received the lowest degree among the media of First Amendment protection. The court's two most important rationales for limiting protection of broadcast expression simply don't apply to cyberspace. And footnote, just as the ACLU thinks the obscenity exception is wrong, we think the discredited or subordinated status of broadcast expression is also wrong. But even assuming that the rationales that have been cited to justify degrading First Amendment protection in the broadcast media, even assuming that those rationales were correct, they surely are not correct when it comes to cyberspace. First, the court has stressed that broadcasters are government-licensed monopolies which control the limited resource of the broadcast spectrum. Second, the court has said that broadcasters essentially commit stealth assaults upon captive audiences calmly, innocently sitting at home or in their cars, and they're suddenly unwittingly bombarded by these offensive images that come over the airwaves. Putting aside the debatability of those propositions with respect to broadcasting, clearly neither one of them pertains to the Internet. First, the Internet is the polar opposite of a government-licensed monopoly. To the contrary, literally everyone in the world could potentially communicate with everyone else in the world. Second, to receive online communications requires a lot of individual initiative and deliberate selection, in contrast to TV and radio. Even the government's expert witness in the Reno case admitted that you would be very unlikely to come across sexually explicit information by accident. You have to consciously seek it out. So for these reasons, there is no justification for any special restrictions to cybercasting. The Supreme Court's rationale for striking down the CDA was that it reduces adults to the level of seeing only what is fit for children. And that rationale is, of course, persuasive as far as it goes. But for me and for the ACLU, it doesn't go quite far enough. We urged several additional reasons why the CDA was unconstitutional, and I'd like to quickly mention those because they could well be used in some of the subsequent and ongoing battles we are fighting against cyber censorship. First, the Supreme Court's rationale didn't go far enough from our perspective because it made two assumptions that are extremely widespread, both of which are deeply flawed. One is that minors themselves don't have their own free speech rights. I mean, in addition to the fact that this law violated free speech rights of adults, it violated free speech rights of young people. The second pervasive assumption that was not challenged in the Supreme Court, it was not necessary for the court to reach the issue, is that minors are somehow inherently harmed by being confronted with sexually oriented expression. On the first point, I'm so proud of the fact that the ACLU has always been in the forefront of defending minors' rights. And notice I talk about minors or young people or teenagers. I think, among other things, it was really demeaning in this debate to talk about protecting children. The law applied to anybody under the age of 18. As we pointed out in our brief, 123,000 college freshmen are under the age of 18. To treat them equivalent to a 2-year-old child and say they are not capable of exercising mature judgment or profiting from access to sexually oriented expression, I think is really demeaning and fortunately consistent with a number of Supreme Court victories we have won on behalf of minors' rights, including minor free speech rights. I think it would be particularly tragic to deny young people access to the internet because they have been disproportionately active in using this new communications resource, not only as a source of information and chatting with their friends, but also in terms of creating online content. Young people have been incredibly vibrant contributors in a way that redounds to the benefit of all of us, minors and adults alike. The second widespread assumption about minors and access to the internet is equally flawed, and that is that somehow there's something inherently dangerous about sexually oriented expression. The government was so smug in the presumption that this is so widely shared in society that the government, in our case, didn't even bother to try to introduce any evidence of any actual adverse impact upon any minor in seeing any of this expression. To the contrary, we did submit evidence. And let me remind you of some of the material that we were defending: Planned Parenthood, information on safer sex and contraception, Critical Path AIDS Project, information about HIV in language especially geared toward young people, a couple of sites designed for lesbian and gay teenagers, which is especially important for those who are living in physical communities where they're denied access to information and support. And based on that kind of material that was being criminalized in the law, we were able to argue that far from being adverse or harmful to minors, to use that well-worn phrase, this information was affirmatively beneficial, in many cases even life-saving. If you think of the epidemic of unwanted teen pregnancies in this country and the rapid spread of HIV and other STDs among teenagers and the sadly high number of suicides among lesbian and gay teens who feel isolated and rejected in their physical communities. Well, time is a-wasting here, and I want to give you plenty of time to ask me questions about this and anything else. I do want to acknowledge that the major rationale for censoring cyberspace is to protect children from materials their parents don't want them to see, including sexual materials. And the argument that is usually made is that various forms of censorship, more recently these include filtering and blocking software, will supposedly facilitate parental or family control. Now, I have to emphasize that I am completely sympathetic with parents' concerns about shaping the education and upbringing of their children. I hope you're bringing up all of your children to be ACLU members. No, I'm just kidding. But the Supreme Court has long recognized throughout this century that there is an implied fundamental constitutional right that parents have to determine the values of their children. And the ACLU has taken many cases to defend that important right. The important distinction, though, and the important fact is that far from empowering parents and families, all of these sensorial approaches, including the filtering software, do exactly the opposite. They are taking the decision and the information away from the parent, away from the family, as well as away from the young person who has his or her own rights, and handing it over to the government. I'm fond of putting it this way, and I got the line from one of my colleagues in the ACLU of Washington. I'll give him credit. He said, you know, the ACLU is a pro-family organization. We just don't believe that Big Brother is a member of the traditional American family. And even less so of the non-traditional families, which of course we also defend. In terms of what we do advocate, and as always, we've been very proactive in advocating measures that would address parents' understandable concerns that would be consistent with civil liberties. We've put out a couple of reports, for example, on the latest censorial rage filtering and blocking software, and I highly commend them to you. One is called Fahrenheit 451.2, is cyberspace burning. The other one is called Censorship in a Box. And the Censorship in a Box, which addressed the wave of moves to require libraries and public schools to install filtering software, advocates as alternatives what has always worked in other media. Remember that benchmark. The First Amendment is the First Amendment is the First Amendment. If you wouldn't like blacklisting or burning or banning of certain books in your libraries, instead, what does the American Library Association and other responsible adults and educators who are concerned with children, what do? They have affirmative recommendations of books that are particularly suitable and educationally valuable for kids of particular ages. And the American Library Association, which has been our wonderful ally in this anti-censorship struggle, as in so many others, has done that very aggressively and very effectively online. A lot of resources for parents and kids. And in our latest piece on this issue, which you can find on our website, we recommend a number of other sites, which including Safe Kids Online, which is put out by the National Center for Missing and Exploited Children, because again, the safety techniques that parents have to guide their kids to follow with respect to the potential dangers of actually being stalked by an adult through the online medium and the way adults have used telephones or face-to-face conversations in the past, not just to express ideas, but to try to solicit the child for sexual contact. And that's going to happen online the same way it happens in other environments, and the same kinds of precautions or similar kinds of precautions are warranted. So we're providing that, and other organizations that are concerned with children's welfare and children's education are putting out that kind of affirmative guidance. On blocking, I just want to throw out one irony, and there's always so much irony when you talk about censorship. John Frohmeyer and I were recalling how when the McQuinlan-Dworkin law was enacted in Canada, the very first book that was banned in Canada was a book by Andrea Dworkin herself. But something similar happened with respect to and it really is sexually violent and gross, absolutely repulsive. I mean, I defend her right to write it and yours to read it, but I just want to warn you. In this context on filtering, one of the religious right organizations that was very strongly advocating for mandatory filtering software to be installed in all public libraries and school libraries was the American Family Association, Donald Wildman's organization, and it was just fine with them that this filtering software, as widely reported, went far beyond sexually oriented materials to include many materials of political and social significance, including any site that said anything positive or even not negative about lesbian and gay rights. That was just fine with them. But then an organization called GLAAD, the Gay and Lesbian Alliance Against Defamation, protested that Cyber Patrol, which is the most widely used filtering software by far, was blocking out literally anything that had any reference to lesbians or gay men. Even if there was an announcement for, you know, a lesbian and gay square dancing club, how all-American could you get, right? That was being blocked out. And to its credit, Cyber Patrol said, you know, you're wrong and you're right, we shouldn't do that, and put a representative of GLAAD on its committee that comes up with the blocking criteria. And lo and behold, the next thing that happens, the American Family Association's website is blocked by Cyber Patrol in the category of intolerance, along with, you know, along with white supremacist groups, because Cyber Patrol decided they were not going to tolerate any bias or prejudice on the basis of sexual orientation any more than they would on the basis of race or religion. And boy, speaking of religion, did the AFA suddenly get First Amendment religion? It was really eye-opening. Here I'm looking at a news release quoting the American Family Association, which complained that they were being blocked because we have taken an opposing viewpoint of the political and cultural agenda of the homosexual rights movement. Quote, really complaining, basically, we're being blocked for free speech. You know, as one of my students would say, hello. And I also got something from the American Family Association homepage called, which was just there in last month, called Filtering Out Morality. They're now suddenly against filters, having been such a strong advocate. And on their website, this article ends by saying this, and I thought it was so wonderful. As Christians get involved in these debates, before they get filtered out altogether, Christians should keep in mind the warning of the great Puritan poet, John Milton, in his classic argument against state censorship, Areopagitica. If it come to prohibiting, there is not aught more likely to be prohibited than truth itself. You know, I'm getting chills. This is not what I expect to see on the American Family Association webpage. So I guess that there's some good that can come out of censorship, right? You develop a passion for free speech. I'm going to end now. Not that there's not so much more I could say, but I really want to say it in dialogue with you and in response to your questions. I'm going to conclude by sharing with you something in the same vein of the American Family Association development. It's an email I got a couple of years ago. In fact, I know I read it the last time I was in Montana, but you weren't all in my audience then. It continues to be one of my favorite emails because it came from a member of the Christian Coalition. Many of us have been hearing accounts of the Christian Coalition's annual Road to Victory conference, which is taking place in Washington today, and I actually heard Ralph Reed, the former executive director, on the radio this morning. I had debated Ralph Reed on the Communications Decency Act on Crossfire, and he, of course, was all in favor of it, and I was all against it. But my biggest fan email after that debate is something that came from a member of the Christian Coalition, and it really underscores the fact that civil liberties is a nonpartisan matter, because support of civil liberties crosses party lines and ideological lines, and unfortunately violations of civil liberties also cross party and ideological lines, but we want to look at the glass half full rather than the glass half empty. So let me end with this Christian Coalition email. Dear Nadine Strossen, I am a mother of two, Christian pro-lifer. As you can imagine, I have very rarely agreed with the ACLU until now. I saw you on Crossfire. You knew what you were talking about. I don't like pornographic material or some of the other material on the net, but the First Amendment says that it can be there just as much as I can. I have emailed Mr. Reed, the 700 Club, and Newt to let them know how I feel. The internet is like computer cable. If you don't want it, don't subscribe to it. If you do, but don't want the kids to see all of it, then use a filtering program. It is my responsibility to take care of my kids, not the government. We, the voters, said that in the last election. I know this is a very strange letter to get and even stranger to write, knowing both our stands on the issues, but I wanted you to know that not all Christians want to be Big Brother. And she then ends by paraphrasing that famous Voltaire passage, I may not agree with you, but I will defend to the death your right to say it. So on that note, I would like to turn the podium over to all of you, or the microphone to you, to exercise your free speech rights. Thank you very much.